So a challenge to the NFA and suppressor restrictions as a violation of the Second Amendment is now up for review in the Fifth Circuit. This is a huge case that I think a lot of people now are going to be talking about once I break this down. So we need to talk about what is happening in this case and some of the critical things that can come out of this. Now, really quick before we jump into this video, I want to thank the sponsor of this video, which is Underdog Fantasy. The NFL season is finally here, and my partner, Underdog Fantasy, is ready to make it even more exciting for those of you that play fantasy football. And with their pick'em game, you can win real money by making sports picks. It's time to turn those hot takes into cold hard cash by going higher or lower on player stats like touchdowns, receiving yards, interceptions, and more. And with Underdog Fantasy, you can win up to 1,000 times your money that you put in. Underdog is available in over 30 states, including California, Florida, Texas, and even Canada. And here are my picks on the screen for the NFL Week 1. And by the way, if you sign up using my code down below, Underdog Fantasy has a Travis Kelce free pick for all customers that use my link. And this Thursday, don't miss out on Underdog Fantasy's Thursday 30. You can apply your profit boost token to any entry of your choosing and get a 30% profit boost. My guilty pleasure every single year is playing fantasy football, and this is just another way to kind of spice things up and maybe make it interesting for those games that are a little bit more boring. So if you're interested, you can sign up using my link down below, deposit, and then use my promo code ARMED to get up to $1,000 in bonus cash. And also you can claim that Travis Kelce free pick that you can only get using my link and promo code. Now, as I mentioned in the intro, in this video, we're going to be discussing a challenge that's in front of the Fifth Circuit Court of Appeals, which deals with the constitutionality of the NFA as it applies to suppressors. The case we're going to be discussing in this video is called the United States of America versus Peterson. This case involves an individual who had a gun store that was operating out of his home, I believe, and then it was raided by local law enforcement and then also the ATF. Now, during this raid, the ATF found a single solvent trap that was not registered or serialized. And because of that one item, this individual, Mr. Peterson, was charged with violating the NFA and was charged criminally for possessing an illegal silencer. Mr. Peterson and his attorneys tried to get that whole charge thrown out using a motion to dismiss, and they argued that the NFA is unconstitutional under the Second Amendment. So they brought a Second Amendment challenge to the NFA and a Second Amendment challenge to that one charge of him possessing an illegal silencer. The district court denied that motion, finding that suppressors are not bearable arms protected by the Second Amendment at all. That decision by the district court is now up for appeal and review in the Fifth Circuit. That means that a pure Second Amendment challenge to the NFA and its process as it applies to suppressors is now up for review in the Fifth Circuit. Now, the facts around this case are very interesting, and both the ATF and Mr. Peterson tell kind of a different story. According to Mr. Peterson, on June 29th, 2022, both federal and state law enforcement officers executed warrants at his home in Louisiana. This was also the location of his business, which was a gun store, I believe, that he operated out of his home. The local sheriff also had a search warrant and an arrest warrant out for Mr. Peterson that they executed at the same time because he was delinquent on some taxes. There was a federal task force that included the ATF, the Louisiana State Police officers, I believe New Orleans Police Department as well, some of the local sheriffs, and altogether, I believe there were 50 law enforcement officers that executed this search warrant and then also the arrest and raid on Mr. Peterson in his home. Now, in the context of the sheriff's search warrant, there was a search and arrest warrant, and again, it was based on the non-payment of those taxes. Mr. Peterson acknowledged that he did receive a delinquent tax notice, but he claims that he gave it to his bookkeeper who was supposed to pay it. I guess it got lost. There was a clerical error. Now, when it came to the federal search warrant, here's where things get a little bit different based on what the ATF is claiming. According to the ATF in their brief, the ATF and local law enforcement went undercover and purchased various firearms and items for Mr. Peterson. The ATF claims as a result of those purchases, they found out that Mr. Peterson was not filing the appropriate forms. And then also there was a lot of issues with tracing items back to Mr. Peterson. They claimed that there were 70 firearms that were sold by his business that then were recovered at crime scenes. And then again, they traced those back to him. But here is where the crux of this case really started. During this search, the ATF found in his personal safe what they deemed to be an unlicensed and unregistered suppressor, and that was in his personal safe in his bedroom. Now, out of this whole interaction, there was only one charge brought against Mr. Peterson, and it was for possessing that one unregistered suppressor. Mr. Peterson's argument is that he purchased the solvent trap in the kit to convert it into a suppressor, potentially into a suppressor, but he had forgotten about that item that he had, and that he just simply forgot to file the forms. And then, of course, he was raided by the ATF and they found it. And on October 20th, 2022, the defendant here, Mr. Peterson, was indicted by a grand jury and charged with violating the NFA. Now, in response to that charge, Mr. Peterson then filed a motion to dismiss the charge that was brought against him. But ultimately, on review, the court here denied that motion to dismiss. And on August 29th of 2024, the defendant was rearraigned and entered a conditional plea, reserving the right to have the United States Court of Appeals for the Fifth Circuit to review that motion to dismiss denial by the lower court. So he agreed to plea out, but he did say that he's reserving the right to appeal up to the Fifth Circuit. The district court ultimately did sentence Mr. Peterson, but now he is appealing up to the Fifth Circuit, and now it's up for review in the Fifth Circuit, essentially to determine whether or not the NFA is a violation of the Second Amendment, and whether or not this charge against Mr. Peterson should have been dropped because the NFA is unconstitutional. So now let's look at some of the arguments made by the ATF to the Fifth Circuit and some of the arguments made by Mr. Peterson on appeal. I do have some issues with the papers that were filed by Mr. Peterson's and his counsel. I find them a little bit frustrating. I think you all would be surprised by me telling you that not once in all of the papers filed by Mr. Peterson and his counsel is there a single reference to New York State Rifle and Pistol Association versus Bruen. They do not make any reference to Bruen in any of the analysis in Bruen, and also the analysis which is now precedent in the entire nation, which is text as informed by relevant history and tradition. Instead, it seems like in the district court, in their motion to dismiss, and now even in the appeal to the Fifth Circuit, the counsel here is using means and scrutiny. To me, this seems like a critical oversight. Bruen is a two-way attorney's best friend right now, and it's the current Second Amendment precedent. And I don't really have a good answer for why it was not being used in this case and why it's not being brought up. Interestingly, the ATF is the one who actually argues their case in light of Bruen and calls out actually Mr. Peterson's counsel for not citing to Bruen at all in any of the papers. In fact, the ATF's brief states explicitly that neither Peterson's motion to dismiss the district court nor his appellate brief in this court mentions Bruen. Instead, he relies on means and scrutiny test that Bruen explicitly rejected. So now let's look at the ATF's brief. In the ATF's brief, they first argue that suppressors are not arms protected by the Second Amendment at all. They claim that they are not bearable items and that they are not weapons that shoot projectiles, and so as non-firearms, they are not protected. At best, the ATF claims that they are just simply accessories, and as accessories, they are not protected. They then go on to argue that even if they are arms, they are still dangerous and unusual, and as dangerous and unusual items, they can be regulated. Now, the last argument that the ATF makes is that the NFA's restrictions are in fact constitutional because this process aligns with Bruen. They argue that Bruen, in some dicta by Justice Kavanaugh, mentioned that shall issue CCW permit schemes could be permissible under the Second Amendment. And so what the ATF is arguing here is that this NFA process operates as a shall issue scheme and is therefore in alignment with Bruen. And the fact that you have to register and pay a tax still doesn't violate the Second Amendment because it shall issue. Now, in contrast, Mr. Peterson's attorneys argue that the NFA does violate the Second Amendment and that it would not pass means and scrutiny. Again, I want to mention that that's not the correct type of two-way analysis, but that's what they present in their briefs. Mr. Peterson's attorneys argued to the Fifth Circuit that the defendant's motion to dismiss must be considered in the context that the indictment charged him with knowingly received and possessed a firearm. Paradoxically, the government now argues that the device for which the defendant received and possessed is not a firearm to deny the constitutional rights of the defendant as provided for by the Second Amendment. I do think this is one of the stronger arguments made in this brief because you have the ATF in their brief arguing that suppressors are not firearms, that they're not arms protected by the Second Amendment, but at the same time, the entire charge, the entire indictment is based on possessing an unregistered firearm in violation of the NFA, aka an unserialized and unregistered solvent trap that the ATF claims is a suppressor and therefore also a firearm. So here the defense is essentially saying that the ATF can't have their cake and eat it too. You can't claim that this is not a firearm, that it's not protected by the Second Amendment, but that at the same time, use the NFA's federal definition that these are in fact firearms. Now, they also talk about the NFA process to register these items, to pay the tax and all that. And they argue that even looking at the Second Amendment context, the process here for the NFA is unconstitutional, and that the process itself is a violation of the Second Amendment. Of course, you had the ATF, like I mentioned, argue that the process is shall issue. So one of the interesting things with this case is the fact that I think this will come down to determining if the NFA process itself is actually a violation of the Second Amendment. Now, in my personal opinion, without some help from some amicus briefs kind of bolstering up the two-way side under Bruen, I'm concerned that the Fifth Circuit will actually receive this and see some easy ways out and simply just reject the two-way claims. And a decision upholding the NFA process can have some downstream implications. It could impact not just the Fifth Circuit, but other jurisdictions, other circuit courts that would then cite to this decision, essentially upholding the NFA process as potentially constitutional, even under the Second Amendment. So that's why I have some concerns about this. This is an important case. I've already contacted some individuals in the two-way organizations to potentially file amicus briefs in this case, because I think this is too important to just let sit and go under the wrong means and scrutiny analysis. So again, really important case. And if anything else changes, I will let you guys know. Also, if you like this video, and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.